Hey guys, Attorney Mark Victor here with the Attorneys for Freedom Law Firm. And I want to give a big congratulations to Arizona voters who finally have legalized marijuana for recreational purposes here in Arizona. So congratulations to the people of Arizona who have finally done the right thing. Now I want to mention we have a big opportunity here right now because as I mentioned in previous videos, there's an expungement provision that comes with Proposition 207. So, first off, if you're somebody who has a case pending right now, that's a possession of marijuana case or possession of paraphernalia case, you may want to give us a call and talk about, or talk to your attorney first and talk about whether or not that case should be or must be dismissed by the court. So that's a motion that you should talk to your attorney about. If you're somebody who has a conviction on your record, unfortunately, already from the past sins of making marijuana illegal, and you want to clean up your record, and you should, you might contact us here at the Attorneys for Freedom Law Firm. Let me tell you a little bit about how this expungement section is going to work. And this is new because Arizona does not have, at least until 207 just passed, an expungement provision for adults. It was only for juveniles in the juvenile court. So first off, this will apply to people who have convictions for possessing, consuming, or transporting 1 ounce or less of marijuana, or 5 grams or less of concentrates, or cultivating 6 plants or less of marijuana if it was at their primary residence and it was not for sale. So if you're in that crowd, if you have a conviction for one of those crimes, you should probably give us a call right away and let's start working on an expungement. Now, how does this work? Also, I don't know if I mentioned, also non-sales paraphernalia convictions are also eligible to be expunged here. So if there's a dispute over whether or not your case, your conviction qualifies, and by the way, I should also mention, it's not just convictions. Even if you were arrested and the case was dismissed, or you were arrested and charged and the case was dismissed, we can seal that up as well as part of the expungement. Why leave a sort of record of this craziness out there in your life, which could come back and bite you later on? We can seal that law enforcement's record of that entire activity. What's important here is you don't have the burden to prove in court that you are in this area where you're entitled to have it expunged. The state has the burden to prove by clear and convincing evidence. It's a pretty high standard. It's not as high as beyond a reasonable doubt, but it's higher than the normal standard in the law of preponderance, which we usually explain as 50 plus a feather. So the state has the burden to prove by a higher standard, clear and convincing, that you don't qualify for the expungement. They may have a hard time proving that, especially if you have an old conviction. So don't be shy about bringing that, even if you think you can't find the records. The court's required to make findings. If the court does find in your favor, it vacates the conviction, it expunges the record. All your rights are automatically restored, including the right to keep and bear arms. Now, the exception to that would be if there's something else out in the world that causes you to be a prohibited possessor, so you can't have a firearm. But if it's only the conviction for marijuana or one of the areas that I've mentioned, you get your gun rights back upon expungement. I think that's very important. All the records are sealed, as I noted. The expungement now can't be used by the state for any purpose. This is different and should be distinguished with what we previously had as a set-aside. If your case has been set aside previously, well, the government can still use it as a prior conviction. They can still mention it, and you cannot say, I've never been convicted. So even if you've been set aside, you should still apply for the expungement because the expungement changes that. The state can't use it as a prior. They can't mention it. You can say, I've never been convicted, if indeed you get it expunged. That's pretty significant, I think, worth trying to get done. So if you are denied the expungement, you have a right to a direct appeal to the higher court to get it fixed. I think that's important. And so this whole project is something that was put in there intentionally by the people behind the initiative, Prop 200. And so now that it's passed, you should definitely take advantage of it. So if you have questions about whether or not this applies to you, absolutely reach out. We're the Attorneys for Freedom Law Firm. You can find us. Just go to the internet, put Attorneys for Freedom in there. We'll come right up. If you want to contact me directly, you always can. My direct email is marc, M-A-R-C, at Attorneys for Freedom. It's attorneys, F-O-R, freedom.com. And if you just have general legal questions that you'd like us to take a look at and maybe get back to you with an answer, you can always send those questions just to questions@attorneysforfreedom.com. Again, my name is Marc Victor. Thanks for listening.